So, given that the lectures are named after Alberico Gentili, and given the history that you've just heard, leaving Italy under religious persecution, ending up as Regius Professor of Law at the University of Oxford, and being a practitioner in London at the Court of Admiralty. He was a barrister, what we call a barrister. So the question that I had initially was what I was going to talk about. And given that history, it seemed to me that the answer was pretty obvious, which is that the way to honor Gentili, to recognize his religious persecution, to emulate his role as a legal practitioner, which I am as well, and to connect it to international law, which of course he was so influential in founding. The only issues that I could talk about were religion and human rights. That seemed to me an obvious set of issues to talk about. So I hope he would have appreciated the topic, if not the substantive arguments that I'm about to make. So what I'll do initially is spend a few minutes just setting out the general trend of what I'm going to be saying over the next 3 days, and then to get into some of the more detailed issues that I'll talk about today. So the first thing I should say, I think, is that it wasn't supposed to turn out this way. So we were told that as societies modernize, the vestiges of religion, certainly public religion, should be essentially done away with. That the notion of secularization, that is the notion that states secularize over time, was meant to mean that issues of religious identification would be pushed more and more into the margins, and more particularly into private life rather than into public life. And the theory, therefore, was that as religion went more into private life, the conflicts between religion and public life would be minimized, would be reduced. But of course, that's precisely the opposite of what has happened, in the sense that in the West and in many other parts of the world, what we're seeing is a resurgence of notions of religious sensibility that increasingly want to enter the public domain rather than leave it. So theories of secularization, therefore, seem to be under significant question. They don't seem to be working out in the way they were supposed to. But religious secularization theories were right in one major respect, which was that there is clearly a major tension between the notions of religion and notions of modernization. There's clearly a tension there. Given that one of the ways in which modernization takes a legal form is in the area of human rights, it's almost inevitable, therefore, that there will be a conflict between resurgent religion in the public sphere and notions of human rights. So what we're going to be talking about over the next 3 days, if you stay with me, I hope you will, is how those conflicts have been generated, how they manifest themselves, and what problems they give rise to in the legal and political context. So today what I want to do is to try to set out what those kinds of conflicts are, how they've arisen, in particular why they've got into courts so often, which is generally not an issue that people have talked about so much. The conflicts with human rights are well known. Why they've got into courts as an area of resolving them is a more problematic question. So I want to try to argue today that the reason why we're seeing the judicial and court conflicts arising is because of changes both in human rights and in the nature of religious controversies. So religion has changed to some extent, and human rights have changed over the last 30, 40 years. So after setting those out, then tomorrow what I want to do is to turn to the question of what courts do with these disputes. And in particular, what kinds of problems arise in courts dealing with these kinds of religious problems. Because they're a particular type of dispute that courts have a particular problem with dealing with. And the question I want to try to explore tomorrow is why that's the case. And then on the third day, and the last day, what I want to do is to connect some of those questions that I've been exploring with the general theory of human rights. In other words, what do we understand human rights to be? What do we understand its purpose to be? What do we understand its function as being in the modern world? And to what extent, therefore, in light of those questions about its function and its role, we can think about theorizing human rights in such a way that is less conflictual with the religious questions that we've looked at so far. So that's the agenda. Today, as I said, what I want to do, you're coming to the front. That's wonderful. Thank you. I feel much less distant now from the audience. By the way, what I should say when I'm speaking is that if there are any burning questions that you have, please interrupt me and put your hand up and just ask a question. I'm perfectly relaxed to continue the conversation as we go on. There'll be an opportunity, I hope, at the end of each of the sessions for more informal question and answer discussion. So I'll leave some space at the end for that, but don't hesitate to interrupt as we go on. So let me start with some, as was mentioned, I'm from Oxford, and the tradition in Oxford is that you have to define the question. Yeah, always. You define your terms. So one of the problems that we have is some of the terms that I've been using up to now are themselves controversial. So I want to spend just a couple of minutes describing what I mean by some of these terms. The first term is human rights. I suspect everybody in the room has a conception and understanding of what human rights means, but let me just say that there are two different ways of understanding human rights for the present purposes. One is a kind of descriptive account of human rights. So what we mean by human rights is we go to the Universal Declaration of Human Rights, or we go to the United Nations covenants, and we say, descriptively, that's what we mean by human rights. So what's the problem? The problem is, of course, that they're defined in such a way as to be very general in their terms. So the purpose of most international conventions, most international treaties, in fact, and I'm sure Gentili would have appreciated this point, is that in most cases, conventions and treaties are drafted to avoid the problems rather than to actually deal with the problems. So in other words, when you're negotiating an international treaty, whether it's human rights or anything else, you try to camouflage the differences between you rather than to bring them out into the open. Right? You want to get an agreement after all. You don't want to continue the dispute. The more you try to bring out the differences between the parties, the less likely it is that you're going to get an agreement. And therefore most treaties are drafted in sufficiently general terms that a lot of the real conflicts are unresolved. Right? And so in the human rights context, what that means is that the terms that are in most human rights conventions are very general and need to be interpreted. And in the interpretation of human rights conventions, therefore, what we see is increasingly a normative understanding being used to interpret them. Right? What I mean by that is that most courts either intentionally and explicitly or unintentionally and sometimes not explicitly bring in their interpretation of these conventions understandings of what they're for, understandings of what the normative purpose is that are used in order to explain the actual terms in practice. So what do we mean by torture? What do we mean by discrimination? What do we mean by speech expression? All of those questions are often interpreted in a way that incorporates a normative, moral, ethical understanding. So we've got two understandings of human rights, a sort of descriptive and a normative. And generally what is going on in many of these cases that I'll talk about is a combination of the two. Okay, that's human rights. Second question that's relevant is that we'll be talking about judicial reasoning in the human rights context. So not just what treaties are doing, not just what's happening at the United Nations, but what's happening in terms of judicial understandings. And the human rights that we're going to be talking about is not just international human rights, but also domestic or national understandings of human rights. So in my understanding of human rights, I'm going to be including notions of constitutional rights. Now, that's a controversial move, right? But nevertheless, bear with me for the moment. When I talk about human rights, I'm going to mean both national as well as international understandings. Judicial reasoning in this context, therefore, is quite important, both at the international and at the domestic level, and increasingly at the domestic level. So the question that is going to arise is, what's the legitimacy of judicial decision-making in this context? Because all courts, all of the time, are faced with a question that sometimes comes to the fore, but sometimes doesn't, which is, why is it legitimate for the court to be deciding these questions? So there's always a question of judicial legitimacy, and therefore a question of how the court goes about trying to justify itself to its audience. And different courts have very different traditions about how to do that. Some courts, some of the French courts, for example, try to say as little as possible in explaining themselves. And that's a way of showing the authority of the court. Common law courts have a different tradition of explaining themselves at very considerable length. There's no one reason why one or other is more legitimate. It depends on the audience. But one of the interesting questions that we'll have to have in mind is what techniques judges use in trying to justify their decisions in these controversial areas. And we'll see different techniques being used. Okay. Third kind of definitional question. So I've talked about religion, so what do we mean by religion? And I thought it's better to get that out into the discussion sooner rather than later, since it's probably going to be at the back at least of some of your minds as to what I'm going to mean. So I could go through a long sociological discussion about the meaning of religion. Many, many hundreds of trees have been destroyed in order to provide the paper for discussions about what we mean by religion. I'm not going to do that. I'm going to suggest that, at least for the purposes of today and tomorrow and the next day, I'm going to be talking about a core set of religions. Essentially the religions of the book, as they're called. So Islam in particular, Christianity in particular, and Judaism. So that's what I'm going to mean in most cases by religion. Now, those have certain key features. Those religions, not all religions, but those religions have certain key features that it's worth keeping in mind. First of all, they usually constitute a set of beliefs. Beliefs in something transcendent. Right? Now that immediately gets into problems, of course, when we're talking about the law. They also usually constitute a set of values. And once we're talking about, therefore, religion is constituting a set of values, of course, what we find is that there are then two sets of values, what we'll call human rights values and what we'll call religious values. It's not that there's just one set of values in play here, it's the relationship between the sets of values that's going to be interesting. It also manifests in a form of practice. So there's a manifestation of religion, usually in the form of certain formalized practices. So it's not just an internal set of beliefs, it's often in terms of the three religions I've just described, it also manifests itself in how you act in public, together, and separately. There's also, finally, an important element that attaches to those religions in the current political climate, in most contexts. And that is that religion becomes a kind of social status So it becomes a badge of identity in many places. Not just a set of beliefs, not just a set of values, not just a set of practices, but also an identity. Right, so at this point I'm going to tell you a joke. Okay? So I'm from Northern Ireland. And in Northern Ireland we have had conflicts relating to religion for some considerable time. Fortunately, we hope that they are no longer going to lead to civil war, but they certainly are manifestly important. Okay, so here's the joke. So a rabbi, a Jewish rabbi, arrives in Belfast and wants to see around the town. And as he's touring around, he's stopped by a gunman, somebody with a gun. And the gunman says, so what religion are you? Because, of course, that's very important. If he's in the wrong religion in the wrong place, then he's probably going to be shot. So the rabbi smiles and says, actually, I'm Jewish. Thinking, that's fine, no problem. It's a religious dispute between Catholics and Protestants, not with Jews. So the gunman thinks for a moment and he says, yes, but are you a Catholic Jew or a Protestant Jew? Right? So my point is, in that context, no one was interested in the beliefs of the person. They were interested in how far religion formed a badge of identity, which had a whole set of important elements to it, which were political, social, as well as religious.
So he had no identity.
So he had a complex identity, which we may get a chance to talk about in greater detail later on. So the last kind of definitional question I want to tackle is that we're going to be dealing with religious litigation. That's the term I'm going to be using to describe the sets of cases that I'll talk about. And by religious litigation, I mean not only to include what in American terms would be thought of as establishment questions and religious freedom questions, but also questions of discrimination on the basis of religion. And also those kinds of cases that arise now all the time in which religious arguments are involved even though the claim isn't formulated explicitly in religious terms. So think about issues like abortion. Think about issues like assisted suicide. Questions relating to same-sex marriage. So those are kinds of issues that get into court where religious arguments are made in the course of the discussion, even though it's not explicitly about religion as such, or about freedom of religion as such. So I'm going to include all of those within the universe of kinds of cases that I'm interested in, rather than the narrower understanding of freedom of religion or establishment questions. Okay, so let's turn to some of the kinds of disputes that we're going to be looking at in some greater detail. First of all, any questions so far? Any burning issues people want to? So you mentioned when I was making my joke about issues of identity and Judaism, and that's the first question I actually want to come to.
Yes, if he wasn't either a Protestant or a Christian, so yet, according to the man who was asking.
Yep.
So probably you have no identity if you are either a Christian or a Protestant. So this is only the just
right.
Without.
Right. So we're clearly into complex territory here. So the first case I wanted to mention is a case called the JFS case. And these are simply examples of the kinds of disputes that we now get into. In this case, it was a case before the United Kingdom Supreme Court, where a school had been set up by the Jewish community in London in the 18th century. Very successful school. And it was then brought into the public school system, into the state school system. But it remained a Jewish school, and it was intentionally meant to be educating Jewish pupils. It was a very popular school, very successful school in North London, probably one of the best schools in London. And therefore, lots of people wanted to come to it. So it was what we call oversubscribed. More people wanted to come than there were places. So the school had to introduce a set of criteria for selecting which students would come. And one of the criteria that it used was whether it was a boys' school, whether the boy was Jewish. It was, after all, a Jewish school. And there are Catholic schools, and there are Church of England schools, and so on, in the English system. So this is not like the United States, where all public schools are non-religious. There are some public schools that are public schools in the state school sense that are religious as well. So the criterion then was whether the boy was Jewish. And in the English context, there is the institution of a chief rabbi. And the chief rabbi is recognized by the state as having certain roles. And one of them was to determine whether someone was Jewish for the purposes of attending this school. So the question arose, was this boy who wanted to apply to the school Jewish? And the chief rabbi decided that he wasn't. And he wasn't Jewish because, according to halakha, according to religious law, Jewish religious law, to be a Jew, you need to have been born of a Jewish mother. So it's a descent-based understanding of how you become Jewish. Unless you have converted, unless the boy has converted to Judaism, or unless the mother, who wasn't Jewish to start with, has converted to Judaism. Yeah? So, in other words, the becoming Jewish comes through the mother, either by birth or by conversion. Okay? So this boy was born of a Jewish father and a mother who was originally Catholic. And I thought it appropriate to use this case to start with because she was originally Italian Catholic. Okay? She had been converted to Judaism, but she was converted under a form of Judaism that was non-orthodox. Yeah? So in other words, there are different strands of Judaism, and she was converted under one of the strands that wasn't recognized by the Orthodox chief rabbi. So the chief rabbi said, he's not Jewish. The boy said, I think I'm Jewish. You know, I wear a kippah, I keep kosher, I'm learning Hebrew, I'm deeply committed to Judaism, I think I'm Jewish. And the chief rabbi says, that's tough, you're not, according to our law. So the boy went to court. And the case ended up in the Supreme Court. And there was a problem. And the problem that he faced was that you would think that the issue that he would talk about would be one of religious discrimination. That he was, discriminated against on the basis of his religion. But according to the English law at the time, there was a statute that provided for religious discrimination cases. But there was an exception for schools. So religious schools could discriminate, obviously, right? Because otherwise they wouldn't be able to remain religious schools. So there was an exception. So the council, the boys' council, decided to not make an argument about religious discrimination, but to make an argument that the discrimination was on ethnic grounds, that it was racial discrimination. Right? You're smiling, you can see where this is going to go, right? So the question then becomes, was he being discriminated against on ethnic grounds? Now, this, of course, connects into one of the points that I made earlier on about religion being a badge of identity as well as a set of religious practices. I was among the council representing the boy. No, I wasn't. I was representing the school. So the point here was, how were we representing the school able to resist an argument about ethnic discrimination? And so what we argued was that there was a difference between notions of Judaism as an ethnic criterion and notions of Judaism as a religious criterion. Obvious argument to make. And the conclusion was, from the Supreme Court, that we were wrong. That the boy had been discriminated against on grounds of his ethnicity. And so he won, and we lost. Okay, so here's the question. The question, of course, is how is the Supreme Court able to decide questions of who is to be Jewish? Now, the decision that they made was clearly contrary to the idea that the chief rabbi wanted to have adopted. So, was that a correct decision or not? Okay, so that's one case. Second case. This is called the Liddell case. And this is a case before the European Court of Human Rights. And this is a case in which a commissioner of marriages, a public commissioner of marriages, that is, someone who is appointed to conduct marriages, public marriages for the state, was dismissed from her job. And she was dismissed because she refused to conduct same-sex civil partnerships. Okay? That is, at the time, this was a few years ago, before the United Kingdom introduced same-sex marriage, there was an arrangement for same-sex civil partnerships, which were equivalent in most respects to marriage. Marriage commissioners were designated as able to carry out same-sex civil partnerships. She refused to do this on religious grounds, and she was dismissed. Now, Islington, that is the council that was able to designate her, didn't have to designate her. They had the discretion whether or not to appoint her to conduct same-sex civil partnerships. And she initially said, please don't, and they went ahead and appointed her. So the law changed after she was appointed initially, right, in order to allow these same-sex civil partnerships. She refused again and was dismissed. We were arguing for Ms. Liddell before the European Court of Human Rights. We lost. And we lost on the basis that the Court of Human Rights said that it was within the margin of appreciation of the United Kingdom whether or not to require her to carry out these same-sex civil partnerships, even though it was contrary to her conscience. Yeah? So again, we lost. You may think there's a trend here, which is that every case that I do, I lose. Right? And that's not always the case, but it's quite often the case in this context. So one of the reasons, of course, why I'm interested in this area is to find out why I keep on losing. Right? So this is partly a sort of self-analysis. So third case. This is called the Hobby Lobby case, which is a United States Supreme Court case. And the Hobby Lobby case arose out of Obamacare. So in other words, you remember that there was a lot of controversy a few years ago when President Obama introduced an element of compulsory health care. And this is a very complex set of legislation, but one of the elements of it was that it required employers to provide their female employees with no-cost access to contraception. as part of the healthcare system. So private employers were required to provide access to no-cost contraceptive advice. This particular employer, Hobby Lobby, was headed by a group who were Christian employees, Christian employers, and self-proclaimed Christian employers. And so they ran the company on what they perceived to be Christian lines. And they were a for-profit corporation, on the other hand. They weren't a kind of charity, they were for-profit. So the question was whether their sincere Christian beliefs that life begins at conception, and therefore the contraception is contrary to their beliefs, whether that was going to be allowed to undermine the requirement in the law that they had to provide this advice. Yeah? And essentially what the Supreme Court had to decide was whether a particular law, which was the Religious Freedom Restoration Act of 1993, allowed the employer to escape the requirements of the healthcare law. And the Supreme Court decided that the employer was not required to provide this advice. Why? Because the employer had a conscientious objection to it, a religious conscientious objection to it. So you can contrast that with the Liddell case, right? And you see quite an interesting difference. In the United States Supreme Court, conscience trumps. In the European Court of Human Rights, in that case, it doesn't. Okay, so that's a third case. Let me turn then to a fourth case. This is a favorite case of mine. Okay? I wasn't involved in this case, but it's a lovely case because it involves a community that adheres to Krishna. Right? And it's set up in rural Wales. So it would be like having a Krishna community out in a few miles from Macerata, right? And they believe that the cow that they have is sacred. So they have a sacred cow. This is in Wales, this is in England, close to England, right? So they believe this cow that they have is a temple cow and therefore is sacred. So it's equivalent to a person. So there's an outbreak of a disease that particularly affects cows called foot and mouth disease, which is a terrible disease that kills lots and lots of cows. And the only way of dealing with it is to kill all the cows in the surrounding area to prevent the disease spreading. So the authorities decide to kill this sacred cow. Okay? And the community goes to court and says, you couldn't possibly have understood the significance of this cow to us if you were going to kill it, because if you really believed that this cow was human, of course you wouldn't kill it, or was equivalent to it. And the minister that they went to said, of course I understand what you're saying, I really appreciate you, of course you're absolutely right, and your religious beliefs are important, but nevertheless we're going to kill the cow. And the court had to decide whether or not killing the cow was contrary to the discretion that the minister could exercise. And they decided that it wasn't contrary, so the cow could be killed. Okay. Next case, Hosanna Tabor. So we're back to the United States here. And this case involved a small church-sponsored school who employed various teachers. And one of the teachers that they employed was also a minister in the school. Right, so she was also able to conduct services for the church. And they got into a dispute and she was dismissed. And she wanted to take a case on grounds of disability discrimination, right? Because she said the reason why she was dismissed was because she had a particular medical condition, and this prevented her from doing her job, and that's why she was dismissed. And the school said, so the schools didn't say there wasn't discrimination, they said the law doesn't apply to us. And the law doesn't apply to us in this case because there's an exception for ministers of churches. And she said, but I'm a teacher. And the school said, yes, but you're also a minister. And because you're also a minister, therefore the law doesn't apply. So the court held that determining who or who was not a minister was not an activity that they were going to go into at any particular depth, and that they were going to essentially leave it to the discretion of the church to decide who was a minister. Now, again, that's interesting. Contrast that with the United Kingdom Supreme Court deciding who was Jewish. Very different kinds of attitudes being displayed here. Whole set of cases that you also may be aware of where the United States Supreme Court considers the use of public symbols in public spaces, religious symbols in public spaces. So, for example, are you allowed to display the Ten Commandments in a court? Are you allowed to display the Ten Commandments in a plaque form in a public space, in a public... And those have given rise to considerable disputes before the US Supreme Court, with very different decisions coming down depending essentially on the particular facts in any particular case. Very difficult to predict how the court is going to decide. And then finally, let's turn to the wonderful Lautzi case. Okay. So when I was here yesterday, I was looking around and I thought, that's interesting. There's a crucifix. So the Lautzi case, so there's a public university with a crucifix. Interesting. Interesting because clearly in other countries, in some other countries, in the United States in particular, you would not have a crucifix in a public university being displayed. You would have it in Georgetown or Boston College, whatever, Catholic universities, but you wouldn't have it in a state university. Okay, so the Lautzi case that some of you will be familiar with is this very interesting case that comes out of Italy, where an Italian public school displayed the crucifix, and the parents of one of the children objected to being taught under the cross. Now, of course, there's a whole series of equivalent cases in many countries about this, most famously in Germany, where there's a very important decision a few years ago by the Bundesverfassungsgericht on just that question. So the question was whether the appearance of the crucifix in a public school in Italy was contrary to the European Convention on Human Rights. Why? Because it was alleged to be contrary to Article 9 of the Convention, which protects freedom of religion, which the boy's mother said also protects freedom of non-religion, and therefore she and her child should be protected from having to be exposed to a particular set of religious beliefs in the classroom. That was her argument. So, did this violate her right, the parents' right, to have the children educated in the way that they chose, free of religion? Now, very, very controversial debate. Initially, the European Court of Human Rights held in what's called the chamber, so the lower chamber of the court, held that it was contrary to freedom of religion. And all hell broke loose. Very controversial decision. Lots of very important governments and non-governments involved in arguing why that decision was wrong. The Grand Chamber that the case originally went to reversed that decision and held that it was not contrary to freedom of religion for the cross to be displayed, for the crucifix to be displayed. So there's an interesting question there about what the meaning of the crucifix is. What is it meant to convey? And that's, of course, an immensely controversial question, not only between religion and non-religion, but also within particular religions. about what we understand the crucifix to be. Now, a previous decision by the German Constitutional Court had tried to interpret what the understanding of the crucifix was. Now, this is a secular court trying to get into an understanding of what's clearly central to one of the major religions believes. That's quite a controversial question to have to determine. So the reason why you've still got the crucifix is because the European Court of Human Rights says it's within the margin of appreciation of Italy to decide whether or not it's going to be accepted. Okay, so those are the kinds of questions, right? This whole string of cases that I've thrown at you are simply the tip of the iceberg of the kinds of issues that arise now in the United States courts, in the Canadian courts, in the British courts, in the European courts generally, and in international and domestic decisions. Okay, so now we have the question, essentially, why? Why are these cases arising now? Why are they arising in courts? Because had we been thinking about these kinds of questions maybe 20 years ago, none of these cases had arisen. So this is really, we may think that this is a fundamental tension, but it's a relatively recent tension in the sense that these issues are being articulated as human rights questions. Right? That's new. We have long histories, of course, of how the state deals with religion, but not how the state deals with religion in human rights terms explicitly. Generally, the reason why we didn't have it was because the freedom of religion was seen to be a human right, and therefore, of course, it had the power of being able to trump other debates, other kinds of policies. Now that no longer seems to be the case, and the question is why. Okay. So in the next while, what I want to try to do is to explain two sets of reasons why we now have these disputes. Okay? So let me pause there and see if there are any issues that arise. I've thrown a lot of cases at you. We will be sort of referring to those as we go on, but I wanted to get them on the table.
Well, you would probably go into this, but the problem, I think there is a problem on the contradiction in conceiving identity that can give this. Well, you talk about the marginalization of the problem of religion, but this is not possible because anyway we have seen most of the cases they have to be with religion or the religion that gets into the identity of a person. So probably, well, this is a question very confusing, I think, because on the conception of identity. But probably just this is I'm very interested on the problem of identity. That's
good.
Why I'm okay. That's why I'm
excellent,
asking this.
And that's precisely one of the issues that we're going to be talking about.
Yeah.
Whether or not I'll satisfy you is another question, but at least I can promise that it will be raised as a central question. Okay, so what I want to suggest in the next while is that there are two sets of explanations. One set of explanations is what I'll call ideological. And the other set of explanations are what I'll call institutional. Okay? So let's start with the ideological points. In order to illustrate these, I'll be using approaches and questions that arise particularly within the Catholic Church. But that's simply as a set of explanations, as a heuristic device. These may or may not be equivalent in other religions, but for my purposes, partly because I know more about it, it provides a good set of examples. But I think it's more broad. So the ideological changes I'm going to suggest that have occurred, that have increased these tensions, are changes both within human rights and within religions themselves. Okay? That's going to be the theme of this part of the discussion. But before I do that, let me just sketch out broadly what the legal approaches are that we're going to talk about. Yeah? So essentially, there are two major sets of legal protections that are in play here in most of the cases that I've mentioned so far. And one set of protections have to do essentially with freedom of religion as a concept. And that's often protected at the constitutional level. So this is an exercise in comparative constitutional law. And by freedom of religion, we essentially mean a notion that certain religious practices and certain religious beliefs should be protected from being questioned or overridden by the state. Now, one good example of this is obviously the United States Constitution, the First Amendment, protecting freedom of religion. It also, of course, protects from religion being established. So we're immediately into a problem here, a tension. And the tension is, how do you at the same time protect religion but not allow religion to dominate? Right? Because, of course, in Europe, in many other parts of the world, we have this dual problem that in some cases religion is suppressed. Think of the Soviet Union. But in the other hand, we also have examples where religion clearly dominates and leads to the suppression of other beliefs. Gentili being, of course, a classic example of precisely this problem, where he has to leave in order to be able to practice his beliefs. So the freedom of religion idea, therefore, is a dual-faceted notion. It has two faces. How do you protect the manifestation of beliefs, and how do you prevent those manifestations from taking over the polity, from taking over the state? Now, there's a key element here in the notion of freedom of religion as a protection. It doesn't talk about freedom from discrimination on the basis of religion. That's an element of it, but it's not the central understanding. And it's the reason why it's not the central understanding is because even if all religions were banned, that would still be obviously contrary to freedom of religion. So even if there was no discrimination whatsoever between religions, freedom of religion would protect. Okay. So the notion then of freedom of religion is a key element in all of this. The problem, however, arises because of this notion about manifestation. So most legal systems are fine about the notion of protecting freedom of religion when it's simply an internal understanding of the person themselves. Right? Partly because very few states, some do, but very few states attempt to actively change somebody's mind from believing in certain religions. Right? We do have examples, of course, of brainwashing and attempts to create an atmosphere where people change their views, but generally, most liberal democracies at least leave people to believe what they want. When they come to manifest that belief in public, it's a different story. Right? So some of the examples we've seen, displaying the Ten Commandments, displaying the crucifix, those are manifestations of belief. So I can perfectly well believe in the importance of the crucifix without it having to be manifested, without it having to be displayed. Once you display certain beliefs, once you institutionalize the practices, then it becomes a relationship with others, and the others may object. So this question then about the extent of how far you're likely to protect the manifestation of beliefs becomes a central question. Okay. So that's one set of issues. Second set of issues, coming back to your identity interest, is more to do with discrimination. We also have constitutional protections, of course, for discrimination, against discrimination. But much more recently, you have a lot of statutes that prohibit religious discrimination. And actually, most of the work that's done legally in protecting against religious discrimination is done through statutes rather than constitutionally. Right. Partly because constitutional protections of equality are often very broad and not very defined. Sometimes they include religion, sometimes they don't. However, now we have, both in the European and North American, US, throughout the world, you now have a series of detailed statutory provisions that prohibit discrimination on the basis of religion. Most recently, of course, what you have in the European Union context is the Council Directive of 2000 that explicitly prohibits religious discrimination in employment, for example. And that has meant that all European states therefore have these provisions in play. So my point here is that in terms of the legal provisions that we're dealing not only with constitutional but also with statute. We're also not only dealing with freedom of religion, we're also talking about religious discrimination. And those complexities, therefore, mean that there's quite a lot of play as to what are the relevant legal provisions to bear in mind. Okay. The other general point I want to make before we get into the details is that I'll be talking about conflicts between religion and non-religion, between secular and religious. But of course, there's an awful lot of overlapping consensus between a lot of religions and human rights provisions. So we shouldn't think about all of this as being necessarily a question of conflict. There are, in many respects, lots of overlaps. So think about socioeconomic rights and contrast that or compare that with, for example, the preferential option for the poor in the Catholic Church. There is quite a lot of overlap in terms of the notion that you need to protect certain socioeconomic rights. And that's both from a religious point of view and from the non-religious point of view. My point is only that we shouldn't overemphasize the conflicts and assume that there's only conflict here. But having said that, I will now concentrate on the conflicts. So where are the aspects of divergence? Well, in particular, and here I'm going to use the Catholic position as a prime example, clearly the role and the approach that the Church takes to the role of women, issues of sexual orientation, contraception, abortion, genetic manipulation, physician-assisted suicide, and that's just the tip of the iceberg. All of these issues are now what the Americans would call hot-button topics, in which religion and human rights are on apparently opposing sides on all of those issues. And of course, those are the issues that we now often think of as being defining questions of modernization. Or take another example, the ratification by the Holy See of human rights instruments as an example of tensions. So, I mean, to put it bluntly, the Holy See's record of ratification of human rights instruments puts it somewhere on the level of Zimbabwe and Saudi Arabia in terms of the number of instruments that have been ratified by the Church. So why would that be the case? Now remember that you can take reservations to the ratification of international treaties. So lots of states take reservations but still ratify. The Holy See does not in many cases. Why? It's a manifestation of the tension in the last 20 or 30 years. Not just that you wouldn't take a reservation, but that you wouldn't ratify at all. That's an important indicator. So why? Why do we have this situation? Why do we have the situation in which the Church, not only the Catholic Church, but also many of the major churches that I've mentioned, are now in court defending positions that seem to be contrary to human rights arguments? So let's start with changes in human rights doctrine. Now, I mentioned that there have been a lot of developments in human rights doctrine in terms of judicial interpretation, but there have also been enormous changes over the last 30 years in terms of the scope of human rights that we now see. So think back to maybe 30, 40 years ago. Think back to maybe 50 years. 1950s, early 1960s. And the issues that were considered to be central human rights questions are now quite different than they are now. So think about the extent to which, for example, there has been a change in terms of the emphasis that's placed on positive obligations of states. So let me explain that. So there are states that sign up to human rights treaties, sign up now to two sets of obligations, essentially. One is a set of negative obligations. Don't torture people. Don't restrict freedom of speech. Don't restrict freedom of assembly. Don't discriminate. Those are negative requirements. But increasingly, these negative requirements are also interpreted as giving rise to positive obligations. So the state, therefore, has to do certain things positively to protect those rights. And that often involves intervening in private situations to prevent the breach of those rights. So increasingly, positive obligations have led to state obligations to intervene in the private sphere, to intervene in private organizations. Because in not intervening, it therefore seems to give an imprimatur, an acceptance of this private violations. So let's take an obvious example that's non-controversial. So there is a right to life. There's a right to be free from torture. That not only requires the state not itself to torture, not itself to kill, but also to protect the right to life from private parties. For example, by introducing a law against murder, by introducing coroner's courts that investigate why people have died, that has quite a heavy implication in terms of the need to investigate why people have died. Or in protection of from torture. Not only does the state not allowed to torture themselves, but equally they must prevent others from engaging in torture, even if they're private. So increasingly, therefore, what we see is the state being driven to intervene in areas that previously would have been regarded as not covered by human rights requirements. And that has therefore led to an increased tension with private sector, if you want. So that's one example. Second, the reason why there's been a change is because of, in particular, identity questions coming to the fore. So from the 1960s onwards, we have a series of interventions arising partly out of South Africa, partly out of the United States, where, for example, racial questions are now regarded as a central part of human rights understandings. So from the 1960s, we have a whole series of conventions dealing with racial discrimination. Then gender discrimination. And the combination of those two leads to, in particular, an emphasis on identity protection as now being a central understanding of what we mean by human rights. And that, of course, has cascaded into many other areas. So disability discrimination, for example, is now often thought of in identity terms. Sexual orientation, in particular, is now thought of in identity terms. To the extent that discrimination on the basis of sexual orientation has moved on, which it obviously has been significantly resisted in the last 20 years, that's often been accomplished in identity language. So think of the change that's occurred in terms of how one deals now in human rights terms with the old offence of buggery, as it's called in English law, sodomy. So in the 1970s, the way in which that was dealt with was as a privacy issue. In other words, the law shouldn't intervene into private life. Now it's dealt with as an equality issue. hence in particular, the expansion of human rights protections that now lead into, for example, same-sex marriage or same-sex partnerships or pension or equal pension arrangements. Those are all in equality terms. Now, what's the theoretical significance of this? The theoretical significance is that increasingly human rights questions essentialist approaches to an understanding of the person. Now, what I mean by that is an essentialist approach has an understanding of the person that particular types of roles are essential to the way in which we understand the person. So think of women. So the notion of caring as being an essential attribute of women is an essentialist approach. Yeah? Quite often it's biologistic as well. Quite often it's presented in terms of that this is the biology of women, and therefore that leads to certain attributes that are essential to our understanding of what it means to be a woman.
Natural
Human rights.
Or cultural?
I'm sorry, second.
Is a natural or cultural attribute?
Precisely so. So often in terms of notions of essentialism or biologism, it's framed in terms of what is natural. And increasingly that's challenged in terms of it being culturally determined or non-essentialistic. Yeah? Increasingly human rights discourse has adopted a non-essentialist, non-naturalistic, constructivist approach to understandings of identity. Now, it's not that you often get courts talking in that language, but it's quite clear that a lot of the challenges to women's roles, to gender, to sexual orientation, are constructed in terms of a challenge to the natural or the unnatural. Yeah? So this combination of factors, I'm suggesting, and these are only two of several, have led to human rights, therefore, entering into fields that previously, 30 years ago, 40 years ago, it would not have entered. A dramatic example is female genital cutting in Africa. Right? 30, 40 years ago, that was a complete unacceptable thing to talk about. Right? It was not a human rights issue. It was explicitly kept out of the United Nations on all occasions. Now, there is a huge movement, a human rights movement dealing with female genital cutting. That's simply an example of a generalized trend of much more intervention into precisely the territory that religion thinks of itself as controlling. Okay. Where are the changes in the religious context? Well, what I'm going to suggest, and again, I'm going to use Catholic examples here, is that increasingly there's been a tension between what have been called revisionist and anti-revisionist approaches within Catholicism. Now, here, let's leave aside Catholics for a moment and talk about sociology of religion. So one of the insights into the sociology of religion, it's quite interesting, I think, is an increasing application of what's been called public choice theory to religion. Right? So, which religions tend to be successful and why? So, one of the theories that's now being popularized is that religions tend to be successful the more they distinguish themselves in brand terms from other religions. So, in other words, if one religion looks pretty much the same as another, why would you bother, right? If one religion looks pretty much the same as secular values, why would you bother? If it's just doing the same job, then it's going to decline in significance. That's the theory. And so, this is sort of Madison Avenue meets the Vatican. Yeah? So, the notion, therefore, is, in sociology of religion, that religions tend to be successful if they have brand identification. How do you get brand identification? Well, one of the ways potentially that you get it is by being pure in terms of your religious belief. In other words, if you set out a brand that is distinct from secular society or from other religions, you're likely to get adherents. You may get a smaller number of adherents, yeah, but you'll get a core set of adherents that are more committed. Yeah, Pope Benedict may have been precisely on these lines. And so what that means is, therefore, that there is a high degree of relevance and salience given to purity and orthodoxy. And therefore you'll want to distinguish yourself by having a clear line as to what is the orthodox position, because that's your brand. Now, I in no way mean to try to undermine the faith elements here. I'm simply describing it as an external analysis using kind of public choice theory. But it seems to me not unconvincing. So what does that mean in the terms that we've been talking about? Well, what it means is that those kinds of reconciliations with modernity that previously were being observed in the Catholic position in the 60s, for example, it's not that surprising that you get a movement against that. And that movement was particularly popularized in a group called the New Natural Lawyers. And they were collected around a particularly important thinker, Germain Grisey, who gathered together a group, and some of the names will be familiar to you: Robert George, Princeton, John Finnis at Oxford, who became very influential in constructing what they called a new natural law. And this new natural law was highly orthodox and was very influential, indeed still is very influential, in the United States. That combination of advocacy, articulateness, and orthodoxy meant that quite a lot of the positions that were being staked out, therefore, in the United States were highly orthodox and were constructed in some way as to create the greatest tension with human rights. Not intentionally, but that was the effect. So think of all of the major issues that I've just mentioned: abortion, contraception, euthanasia. Those are all areas that the new natural law have particularly emphasized as distinct orthodoxies. So what I'm suggesting then is that the elements that we've been talking about are both push and pull factors in terms of changes within human rights being more interventionist in areas that they previously had been excluded from, in terms of some developments within religion being more orthodox than the human rights trends were indicating. So that's two changes on the ideological. I'm going to mention two others briefly. The third change, the third ideological change, is a result of migration. So migration clearly has been extremely important in this area because it has brought groups into societies with religious beliefs that previously were not particularly important in those contexts. And that's led to an adjustment problem. Think of Islam in Western Europe. So what's the issue there? What's the ideological issue there? The ideological issue is the role of multiculturalism. So how much ideologically are we committed, particularly in the Western context, to multiculturalism as an ideal? And the trend probably before the 1990s, the end of the 1990s, was very much towards accepting the notions of multiculturalism, including minority religions, as now to be integrated into the society. Since 1999, or since 2001 in particular, since 9/11, that whole multicultural acceptance is now under considerable strain. And what you're getting in particular societies, and the United Kingdom is, I think, a classic example of this, is where multiculturalism is being questioned as itself potentially contrary to liberal values. Why is that? Because what it seems to indicate, what multiculturalism seems to be indicating, is an acceptance of plurality of views, particularly in a religious context. Where, however, for example, Islam seems to be adopting views that are contrary to gender equality, then it comes up against modernity. And multicultural acceptance is then itself under threat. Right? Because multiculturalism then seems to be protecting discriminatory activity by these minority groups. Now, I'm not accepting or rejecting any of that, I'm simply describing it for the moment. What that means is that once you start to question multiculturalism in that way, not only do you see challenges to Islamic practices, for example, in terms of wearing the veil as being one example, but you also get increasing questions relating to the acceptance of other religious practices. In the, as it were, longer term religions. Why? Because equality means that you can't criticize Islam if you're not also criticizing the longer term religions. So a lot of the acceptance of particular practices that previously would have been uncontroversial now come under question because the whole system is now more under question. So, let me give you the one example that I've mentioned so far, the JFS case, in terms of who's Jewish. That case would probably have been inconceivable 20 years ago. Now it's not only inconceivable, but he wins. And he wins in part because the whole assumptions about what was acceptable and what not acceptable now come under increasing question. Third ideological move. A third ideological move is that religion increasingly becomes, in the last 20 years, a geopolitical football. So what I mean by that is, and Islam is again a good example, of where the religious question enters into the geopolitical competition that's going on. So think of the tensions in the Middle East, think of the tensions between the Islamic world and the Western world. Quite often there's a religious dimension to that. I don't mean religious in the sense of particular beliefs, though that sometimes is the case, but also the notion that there is a culture and identity question that arises. So I think in the context, for example, of debates about how far you want to regulate blasphemy, this has come into the international dimension quite heavily. So there's been a move, for example, by a number of Islamic states to have protections against blasphemy. Now, what does that mean? What it means is the extent to which you want to provide protections for what is perceived within particular societies as blasphemy. Think of the cartoons. Think of the cartoons about Muhammad. So that isn't just a Western, what's happening in Denmark or what's happening in France. It's also been internationalized. And therefore, at the international level, in human rights terms, you're getting a debate as to how far, for example, there should be protections against blasphemy. Another example, maybe a more important example, because the blasphemy failed to get international traction. In terms of a recent proposal by the Russian state, a number of resolutions before the Human Rights Council at the United Nations to have acceptance of what are called traditional values. Right? So 3 resolutions have been passed by the Human Rights Council in the last few years protecting traditional values. Now, what are traditional values? Well, some indication of it is from a speech that the Russian Orthodox Metropolitan Kirill gave to the Human Rights Council a few years ago. So this is what he says. A claim is made that the development and implementation of human rights principles such as human dignity, are increasingly diverging from the original grounding in religious values, as attempts are made to separate it from its origins, and religion is becoming marginalized and privatized. Right? So he's arguing, therefore, that you want to reintegrate religious values into the understanding of what we mean by human rights. And then he goes on, the influence, and I'm quoting here, of extreme feministic views and homosexual attitudes, whatever that is, together with the increasingly important role of a small group of experts and non-governmental organizations, means that the approach of those whose role is to develop and interpret human rights norms increasingly diverges from the opinion of believers and the moral norms accepted by most people. That's what he means by traditional values. And that's the meaning that was attributed by the Russians when they introduced these resolutions, which have now been accepted. So what does that mean? What you're getting, therefore, is that traditional values are being used as another way of presenting the religious dimension to these questions. Now, these resolutions were themselves supported not just by the Russians, but also by significant groups from Africa, Asia, and the Middle East. That's geopolitical. Right? This is a way of distinguishing that bloc from Western and American attitudes. So what you're getting, therefore, is an alternative interpretation of what we mean by human rights, seen in religious terms. Okay, so 4 changes ideologically. 1, changes in terms of the meaning of human rights internally. 2, changes in terms of religious understandings of how orthodoxy needs to work. 3, changes from migration, and 4 changes from the geopolitical aspect. Okay. So what that means is that we therefore have a picture, if I'm right in my argument so far, that leads, not surprisingly, to increased tension between human rights and religion. But we need one further piece of the jigsaw. And the further piece of the jigsaw is, so why do they come to court? Right? These issues could have been kept at the international level of negotiations. They could have been kept to Human Rights Council kinds of decisions and debates. Why do they get into courts? And in particular, why do they get into domestic courts? So one reason clearly, and now we're into the institutional questions that I promised. So one reason clearly is that there's been an increased number of courts. So in other words, if you contrast now with what was going on 30, 40 years ago, the number of courts that are dealing with human rights issues has expanded exponentially. Not only at the international level with the criminal courts, the international criminal courts, but also at the regional level. So now think of the European Court of Human Rights, think of the Inter-American Court, we now have African courts of human rights, increasing pushing for an Asian Court of Human Rights, and so on. So you just have an explosion of human rights courts. And I don't want to underestimate the importance of that development, but it's only part of the story. And the other part of the story that I want to finish with is the role of non-governmental organizations. So, in other words, cases don't get taken by themselves, right? Courts don't go often and look for cases and bring them in. They don't generate the cases. Somebody else has to generate the case. So the question is, who's generating the cases? And one of the groups that's most important now for an understanding of the pattern of litigation that's going on is the role of non-governmental organizations. Now, we know, and it's been well known in the political science literature for a long time, that non-governmental organizations are important actors in domestic and international affairs. That's not controversial. What's much less well known is what role they're playing now in litigation. Right? So in other words, they've capitalized on their political success, and they're now increasingly seeing the courts as another way another forum in which, as it were, the political is being manifested. So that's what I'm going to talk about in the next few minutes. So what do we mean by a non-governmental organization? Well, there's been a classic definition given, which I'll quote. It's a private, voluntary, non-profit, non-violent group with formal institutional character and aiming at some form of social change. Right? That's what I mean by a non-governmental organization. So not only are they playing a political role, but they're playing an important role increasingly in human rights. And the reason for that, in part, is because the United Nations provides an important source of legitimation for these bodies. Why? Because of the consultative status that these organizations have before ECOSOC, before the Economic Social Council of the United Nations. So there's a mechanism by which ECOSOC can formally approve a particular non-governmental organization as having consultative status before the United Nations. This is a tremendous plus for a non-governmental organization. It's useful for fundraising, it's useful for publicity, it's useful for legitimation. So a lot of NGOs want to get this consultative status. But it has two forms, right? So there's all the kinds of non-governmental organizations that you would think of. Think of Human Rights Watch, think of Amnesty International, and so on. But there's increasingly also a group of religious NGOs in front of the United Nations. So organized religions, therefore, have often generated spin-off groups set up in NGO form, which effectively represent them. Well, represent is too formal a term, which present similar views to those of organized religions. So Jeffrey Haynes has recently done a study of UN-focused faith-based organizations. And he's now identified over 300 groups for the UN, which is about 10% of the more than 3,000 NGOs that have access to ECOSOC. So this is a significant group within the United Nations. And what we have is not only they're being used for policy, but also increasingly, as I said, litigation. So we have clearly litigation opportunities for secular NGOs. So think of many of the major cases that have now been before the United Nations or the United States or in front of the European Convention on Human Rights, for example. Quite a lot of those are influenced in one way or another by NGOs. And this is important because what you get, therefore, is the cases being determined in some way by the agenda that the NGO wants to pursue. So these, in other words, cease to be simply individual cases. They are often cases that are either initially or become symbolic of a much broader question. They're no longer just settling individual disputes. They're also settling a larger social question. So what you get, therefore, inevitably, is strategic litigation. And lawyers are obviously familiar with strategic litigation, and we do it all the time. But nevertheless, what you're getting, therefore, is a particular set of NGOs that see the religious question as an opportunity for strategic litigation, either for or against. So the mechanisms by which NGOs influence litigation is either by taking the case in their own name, sometimes. So those states that allow group litigation, where the NGO can go itself to court in its own name, that's increasing. Or where they're indirectly financing the case, but an individual is the main litigant, but they're backed by an NGO financially. Or, and this is also increasingly the case, where NGOs participate as what are called amicus curiae. That is, where they present arguments to court They're not the parties to the court, but they have the opportunity to present arguments to the court. Right? And this developed in particular in the United States, but has increasingly come into the European context as well. So, the United States is clearly one of the best developed examples of NGO involvement in religious litigation. That's undoubtedly the case. So all of the cases that I've mentioned that arise from the United States have a strong NGO backing or involvement. And that's historically been the case for many years. So much of the free exercise, the freedom of religion jurisprudence in the US was prompted by two minority religious groups, the Seventh-day Adventists and the Jehovah's Witnesses. And now increasingly the Mormon Church is getting involved in litigation. So the growing involvement of NGOs has to do partly with their role in American political life, but also with the centrality of the US Supreme Court in political life generally. So in other words, if you're a canny, if you're a well-organized NGO, you're going to want to target your resources to the institution that has the most chance of delivering a successful change in the society. And increasingly, that's the US Supreme Court. But what's been interesting, I think, is not just that these organizations are acting internally in their own countries. So the number of NGOs litigating in the US has grown exponentially, but that increasingly NGOs are engaging in transnational litigation. Okay. So what do I mean by that? What I mean is that an organization in the United States will seek opportunities beyond the United States to make similar arguments that they're making in the US. Okay? So what you're getting, therefore, is with the increasing openness of courts throughout the world, the increasing recognition by courts throughout the world that they're operating in a global environment, increasingly courts have been accepting arguments from groups outside the jurisdiction, intervening in their cases. Let me give you some examples. I mean, some of the examples are really quite interesting. So, for example, in the context of recent European litigation, there has been intervention by one group in a Swedish case in which a pastor was accused of giving homophobic speeches in his church. He was prosecuted. American NGOs come in and support. Or in Romania, the Constitutional Court had to decide whether the ban on same-sex marriage was constitutional. Again, American NGOs come in on that issue. So what I'm suggesting, therefore, is that this transnational NGO activity becomes important because it generates approaches to religious litigation that draw in different approaches from different countries. In other words, you no longer simply in the United Kingdom deal with what's going on in the UK law. You're increasingly being influenced by groups coming in and telling you what's happening in Italy, or what's happening in Romania, or what's happening in the United States, particularly the United States. And so what you're getting is a plurality of views that opens up the court's view as to the possibilities of decision making. So regional human rights courts have been increasingly popular as targets, and in particular the European Court of Human Rights. So what you see in the Lauzzi litigation, the Italian case that I mentioned, was that there was leave given by the Court of Human Rights to several non-governmental organizations to intervene in the case and present their views. Or in cases dealing with abortion, for example, in a recent Irish case, there were numerous third-party submissions presented to the court. Now, in the main, I don't want to exaggerate this, but in the main, the most successful groups that have intervened transnationally are American conservative non-governmental organizations. So let me give you some examples. So one of the main ones is a group called the European Centre for Law and Justice. It's based in Strasbourg. You will, by the way, not have heard of any of these, which is quite interesting in itself. So it was established, the European Centre for Law and Justice was established as the European arm of the American Centre for Law and Justice, which is a conservative religious NGO which was essentially targeting US courts in litigation and is now targeting the European Court of Human Rights. Why is it set up in Strasbourg? It's set up in Strasbourg in order to give it as close access to the Court of Human Rights as possible. It has intervened. It was the group that intervened in Sweden. It was the group that intervened in Romania. Now, why is that happening? Right, so why would American NGOs be interested in religious litigation outside the United States? Because most of these conservative organizations are highly American-based. They're often very, very, very resistant to foreign jurisprudence coming into the United States. They're usually on the other side when somebody is attempting, particular liberal groups are attempting to bring in foreign jurisprudence. So why would they therefore want to litigate externally? Well, this all has to do with the reactions after the Lawrence case in the United States. Okay? So the Lawrence case was a case in the United States Supreme Court dealing with the criminalization of sodomy. Right? So this is the case essentially where sodomy was regarded as a criminal offense in many states. And the United States Supreme Court had, in the 1980s, decided that it was constitutional. In the Lawrence case, it decided for the first time, this was in the mid-90s, it decided, sorry, mid-2000s, it decided that it was not unconstitutional. So sodomy struck down by the United States Supreme Court. And this was the beginning of the serious litigation in the United States about same-sex equality issues. Until you got rid of sodomy, it wasn't going to move forward because it was always criminalized. Once you got rid of sodomy as a criminal offense, then you could move more seriously onto the equality dimension. So the conservative reaction to Lawrence was very, very considerable. This was regarded as a key conservative loss in the culture wars. And you know the famous term, the culture wars, goes back to Bismarck and Germany, Kulturkampf, the notion of a continuing tension conflict between the state and religion. So Lawrence was regarded as a key failure by American conservative organizations. But here's the controversy. The controversy in particular was stoked up, was increased, because the Supreme Court referred in its decision to a European Court of Human Rights decision. Now, you may think this is, what's the big deal? Why is this controversial? In the American political context, it's highly controversial because the United States conservative movement, as I've said, increasingly saw this penetration of the US Supreme Court by foreign jurisprudence as contrary to American interests, contrary in particular to American conservative values, contrary in particular to the notion that you interpreted the Constitution in terms of what it was meant by its text and what it was meant by its history. So it goes against originalism, it goes against textual interpretation, and therefore is to be opposed. The fact that it was also usually introduced by liberal groups meant it was also to be opposed. So Lawrence is not just a failure of the conservative movement to protect sodomy as a criminal offense, it was also a failure because the court relied on a European decision as part of the reason for upholding the unconstitutionality. So since then, American conservative groups have therefore seen the European Court of Human Rights as a potential threat in American constitutional decision-making. because essentially liberal groups were going to the Court of Human Rights, pulling out the jurisprudence and saying to the US Supreme Court, well, look, if they can do it, why can't you do it? So since then, these American conservative groups, therefore, have targeted the European Court of Human Rights in order to prevent the Court of Human Rights making liberal decisions, which could then be brought back to the United States. So it's a very sophisticated strategic litigation move in order to prevent a potential problem for the US, as they see it, occurring in the European context. That's why the European Court of Human Rights is not just a central European actor, it's also a global actor because of its influence. So, last institutional point. So remember, what I've been trying to do is to explain why these cases get into court. So it's not just the increased number of courts, it's also the increased number of NGOs, relatively well-financed, willing to bring their issues into court and seeing the courts as a litigation opportunity. There's one last institutional point that I want to make, and that is the increasing intra-religious factionalism. In other words, what we're increasingly seeing is, because of the form in which NGOs can be established, of groups within particular religions setting up opposing NGOs, both of which claim to be representing an important part of a religion. You see it within Muslim groups, you see it within Jewish groups, you see it within Christian groups, including Catholic groups. And it's quite interesting when you see a list of, for example, NGOs before ECOSOC, before the United Nations, how many of them have a religious title in their name, and how many of them are actually on opposing sides of particular issues. So in other words, what you're getting is these opposing liberal and conservative, as it were, NGOs within particular religions also going to court and trying to persuade courts of their particular approach to the religion that they want to see adopted. And one of the ways of getting greater publicity as NGOs is by going to court. And there are several different examples of those occurring, most recently in the Canadian context, for example, where there's a question about whether to establish Sharia tribunals, and Muslim groups are on both sides of those disputes. Okay, so what I hope I've been showing today is essentially that the relationship between human rights and religion is becoming more conflictual rather than less. And that has to do with the changing role of religion, changing debates within particular religions, and the changing role of human rights, and the salience, the importance of religion in geopolitical disputes, as well as the effect of migration in, again, introducing greater diversity and therefore potential for greater conflict. That's what I've been trying to do today. What I want to do tomorrow, very briefly, just to give you a sort of taste, if only so that you can decide not to come, is that what I want to do is to then turn briefly to look at what happens when these cases get into court. Right? So far, what essentially we've been doing is sketching out why they're getting to court. The question then becomes, what happens when they get into court? So what do the courts do with these questions once they arrive? And what I want to try to suggest, and this is where I'm beginning to get into controversial territory. I mean, some of what I've been saying today is controversial, but not a lot, because it's been mostly descriptive and analytical. What I want to try to do tomorrow is to suggest that there are three essential problems that mean that the courts have very considerable difficulty in dealing with these kinds of disputes. And that these problems are not unique to religious litigation, but they're particularly increased, their salience and their difficulty is increased in the religious context. So what are these problems? And this is where I now begin to use terminology that initially is going to seem extremely alien to some of you. Okay. So I'm going to suggest, let me get these words out first of all, and then I'll explain what I mean by them. The three problems are problem of teleology, problem of epistemology, and a problem of ontology. Okay, now what do I mean by that? And this is to give you something to think about overnight. So the problem of teleology is the problem that the courts face of trying to decide what precisely the human rights protections that I've just been talking about, what they're for. What exactly are they trying to protect? So we've mentioned freedom of religion, and we've mentioned protections from discrimination, for example, on the basis of religion. What's the end that these protections are serving? And there is essentially, I'm going to be arguing tomorrow, no real agreement as to what they are protecting. Different courts at different times, different judges in different times take different views. And it's not just that they are different, they're also conflicting views of what the purposes of these protections are. So are they a way of protecting minorities? Are they a way of protecting the vulnerable? Are they a way of protecting particularly fundamental beliefs? What's the purpose? Depending on what the teleology is, depending on what the telos is, the aim of these provisions is, you're going to get different results. Okay. That's one problem. Second problem is what I'm going to call the epistemological problem. And by that I mean essentially the problem of how one normative system understands another normative system. So how is it that as a judge, imagine that I'm a judge for a moment, how am I to understand, coming from a legal tradition, what, for example, Judaism believes? How am I to understand what Islam believes? So the epistemological problem is how we can get to grips with really understanding a set of beliefs that we do not necessarily share. Is that possible? Now, I don't want to make the grander claim that it's never possible to understand anybody ever, right? So I'm not going all postmodernist on you, right? I want to make a more limited claim, which is that there's a particular difficulty in one normative system understanding another normative system's presuppositions and beliefs. The third problem that I want to try to identify is what I'll call the ontological problem. And by that, I mean what it means to be human. So this is perhaps the most ambitious part of the discussion. Why this is a problem is easily summed up. So we're dealing with questions that are labeled human rights. And so far we've been talking about the rights dimension. And by the rights dimension is who is able to claim, what's the basis of their claim. But we've neglected so far the important question of human in human rights. Why is it that human rights are regarded as focusing on the human? And what do we mean by human in this kind of context? And the reason why this comes up is because increasingly there is disagreement on the foundations of what we mean by human rights, what they're for. So essentially the story is that in the 1940s, when the Universal Declaration of Human Rights was being negotiated, for example, most of the delegates were able to agree on what was wrong, but they were usually unable to agree with why they thought it was wrong. So we're against torture. Why are we against torture? And once you got to the why question, then things split apart, because different groups were putting forward different views about why they thought human rights was important. So essentially the agreement was reached. Let's not get into the difficult stuff. Let's just agree on what the rights are and leave to one side the question of why we're against particular rights violations. We don't need to describe that. We don't need to discuss that for the moment. So we'll bracket it. We'll leave it to one side. Unfortunately, or fortunately, when you come to interpret the rights, then increasingly the question of, for example, why you're against torture comes into the interpretation of what you mean by torture. Why you're against discrimination comes increasingly into the question of what kind of discrimination you want to prohibit. So this question about what the human is in human rights becomes a way into the theory of human rights more broadly. And again, what we see in the religious context is you get very, very different understandings of what it means to be human in the context of discussions about human rights. This is essentially the question that often arises in many jurisdictions about what we mean by the notion of human dignity. Right? So in many jurisdictions, increasingly so, the explanation that's given about why we are so concerned to protect human rights is because we want to protect human dignity. And the ontological question that arises in that context is, what is it that we mean to be human in such a way that particular kinds of things are for or against human dignity? That becomes an essentially contested question in the judicial context because, not surprisingly, courts are not very good at deciding why exactly we're human and what exactly it means to be human. Yet it seems to be an important part of the interpretive function. And in particular, and this is my final point, in particular it arises because different understandings of what it means to be human give different emphasis to religion. So for some religions, the notion of what it means to be human is to be religious. That's a central part of the understanding of what it means to be human. And therefore, if you take that view, you're obviously going to elevate the religious to a very, very significant, indeed a core understanding of what it means to protect, therefore, human rights. If you take a different view of what it means to be human, you're going to have a different view, therefore, of the role and place of religion in that understanding. It's going to be, quite often, much more marginal to the understanding of human rights. So I'm going to suggest that the ontological question becomes a key variable and a key conflict. That's for tomorrow. Day after, then, of course, we'll try to solve all these problems. Maybe. Thank you.
Thank you very much for a really fascinating lecture, which gives a lot of interesting suggestions. And actually, I have a long list, but just to stick on the issue of pluralism and respect to human rights, I will limit myself to a couple of questions. The first one is, if you think that this litigation of human rights and religion should be also considered a way through which human rights become more universal. In the sense that you rightly say that human rights were somehow, in the technical formalization of human rights were happen in events which didn't really see a kind of inclusive involvement of the whole planet. So you have some decision-making countries, leaders who play the major role. So somehow this process of litigation can also reflect the process through which those human rights really become universal through this tension of different issues. And this brings me also to a question which is related about the tension between secularism, secular view and religious view. We grew, at least I was brought up with this idea that secularism was kind of universal, possibly dominant view, and I have the feeling that this view is increasingly challenged because probably secularism was a much more elitist and not universal view of the world. The second question, very quickly, is about this tension between multiculturalism and the way multiculturalism, you said in the UK debate, was criticized as a challenge or a danger, I don't know exactly, to the liberal view of the world. And my question is, isn't there also a kind of essentialized reading of religions? Because there is the idea that there is Islam, or there is Christianity, or there is Judaism, and that excludes the very fact that all those religions they don't exist basically. You have so many ideas of what is Islam, what is the correct view of Islam, Christianity, and the example you provided on female genital cutting or mutilation, I think is a case in point, in the sense that there is no religious connection from my point of view with this issue, because there is no call for female genital mutilation in Islam and Christianity. For instance, the country from which I come, Eritrea, it is practiced by everybody, being Christian, Muslim, or so-called animist. So there is this danger of a kind of essentialized reading of religion in this discussion on multiculturalism.
Thank you. No, I'm grateful for those questions. They're very much on point. Let me start with the second one on the multiculturalism. I absolutely agree. I hope I wasn't being interpreted as supporting the move, but rather using it as a way of illustrating why these tensions have arisen. In terms of the particular argument about multiculturalism versus liberalism, where multiculturalism is seen to be protecting religions, I quite agree. I mean, the set of understandings of religion that's often portrayed in the liberal critiques of multiculturalism is often highly essentialist and often quite ignorant. I mean, not just essentialist in a sophisticated way of trying to look for the core, but also of dragging into particular religious understandings what actually, as you rightly said, is much more cultural or tradition-based, without any understanding that there may be a difference. So I quite agree with that. The problem, however, is that, and if I can get back to the sort of litigation context here, I think one of the problems that arises is that in a litigation context, either for or against a particular practice, you want to be as simplistic as possible. And so you're almost driven as a litigator to become essentialist in order for the point to be made as crisp and as clear to the judge as possible. So the last thing you want, unless you intentionally want to confuse the judge. No, seriously. I mean, sometimes you can adopt a strategy of trying to throw so many things that the judge says, oh, I can't deal with this, right? And therefore walks away from it. And if your strategy is for the judge to walk away, then you've been successful. But if you're actually trying to persuade the judge of a particular point, substantively, then you want to make it as clear and as crisp and as uncomplicated as possible, because you've got a limited amount of space in which to do it. Yeah? And so there is, unfortunately, I think, a premium almost set on essentializing religion if you want to get a point across about what a religion believes. And that's a real difficulty. And it's part of what we're going to be talking about tomorrow in the context of this epistemological problem of how you get to understand what another religion is. I think your point about essentializing comes in there really quite well. So maybe we can pick up that point again tomorrow. But thank you for that. In terms of the universal, the universalizing tendency here. So essentially, this gets us into the old question about cultural relativism versus universalizing understandings of human rights. And for a long time, most theoreticians of human rights thought the problem had been solved, right? That there was no longer a debate. And Fortunately, unfortunately, that's clearly not the case. And the debate is now as ferocious as it was 20 years ago, 30 years ago. And religion plays a role in that. So an example of where this increasing tension doesn't lead to a universalizing is in this traditional values resolutions before the United Nations that I mentioned. And explicitly, one of the reasons why Metropolitan Kirill wanted the Russians to introduce these resolutions was in order to de-emphasize the universality argument. All right? So what he wanted to do is to say, traditions are important in human rights, and traditions have to be understood in a national context. And so the notion that you would have international courts or even regional courts deciding, therefore, what was acceptable or not, cut across this notion that it had to be really understood in a national context and couldn't be understood beyond it. Now, that happened to coincide, I have to say, with a high degree of self-interest in the Russians, because they were getting criticized time after time in the European Court for breaching human rights. So it did happen to coincide with a degree of Russian self-interest that it should revert to the national. For Putin's new Russia, resurgent Russia, very, very nationalistic. So what I'm suggesting is that some interpretations of human rights that, for example, would incorporate a larger element of tradition don't necessarily go universalizing. Yeah? On the other hand, you're quite right that some of these developments that I've been describing do have universalizing tendencies in the following sense. That increasingly courts are cross-referring to other jurisdictions in attempting to understand their own national protections. Right? So it's now by no means uncommon in quite a lot of jurisdictions, either explicitly or implicitly, to refer to what other jurisdictions are doing on a particular issue. So from that point of view, there's an element of a kind of judicial dialogue developing among a relatively small number of countries, but influential countries, that see their audience as not just an internal audience, but also an external audience, and want to connect with that external audience. Yeah? If that's an element of universalizing, in the sense that you regard the global discussion as relevant to what you're doing. Yeah? Whether it's leading to universalizing in the sense of a common understanding of the substance, that's more questionable again. Yeah? And one of the good examples, I think, of this is the increasing use of, I mentioned, the increasing use of human dignity as a term in human rights discourse, judicially as well as extrajudicially. So the question, and this may be one of the articles that you've been reading in your class, one of the questions is whether there's a common understanding of what you mean by human dignity. So courts will cross-refer to each other in terms of human dignity. Canadian courts will refer to the South African Constitutional Court and refer to dignity, and so on. Do they have a common understanding, however, of what it really means? More doubtful. More doubtful. So I think we're still in the process of deciding how universal the substance is, even though the process is becoming more universalizing. And what I've been talking about so far is the process of litigation. I think that is becoming more universalizing, or at least more globalized, is probably the better word. Whether the substance is more universal, I think, remains to be seen. What I'm going to be suggesting, actually, to sort of give you a preview, in terms of the third lecture, this is actually precisely the issue I want to get to. And I'm going to be suggesting that it is not necessarily the case that's either what's happening or necessarily what we want to happen. So I'm not assuming, therefore, that the universal is necessarily the best way to try to get to. But that's for the third discussion. Thank you for those questions. Those are excellent.
Yes, here. Rose.
Hello.
Yeah. First of all, thank you so much for detailed information about different very interesting cases from America and Europe. It's not maybe a question, it's maybe a theme, focusing on the secularized Western nations. Over there, we cannot hear. Focusing on that, so I will try to focus on the secularized nations in the Western countries, like let's say the European Union and the United States. Here, I'm much in favor of the recognition of freedom of human rights, but not for your religion, recognition of the freedom of religion, but not for the protection of religion. Right. And at individual level, here we might be more than 100 people. So we have different kinds of interests at individual level. It's not easy to have a common view on something. And when we consider the religions, litigation of religions, the religions, three religions considered mainly Judaism and Christianity and Islam. Even two religions, within themselves, they don't have that line of identification, as you say. You were saying, talking about the line of identification. We didn't have that line of identification. How do you, expect from them that the interpretation of their religion and the non-religious people is right, wrong? In the secularized states, religion and the state are two different brands. So here, in order to avoid problems and also facilitate the function of the state, and also equally apply the state laws, why the states, the governments, don't take a neutral approach to apply the state laws and don't consider those minority and protecting those minority groups?
Excellent.
Thank you.
No, thank you. So I think there's two points, if I may take out of that. And you weren't asking questions, so I won't respond to it as if you were. But it strikes a chord in my mind on 2 points. So the first is that you said that the religions themselves don't have a clear understanding of how the state should react to them, just as the state doesn't have a clear sense of how they should react to religion. So I absolutely agree with that. And I think what's interesting is that part of the changes that I mentioned within particular religions are actually trying to work out precisely that question about what they think how the state should react to them. And I'll give you one example that I'm familiar with. The other religions I'm less familiar with. For example, in the Second Vatican Council in 1965, there was a very important document that was produced on freedom of religion, which essentially, though this is not how the Catholic Church would describe it, but essentially shifted their position remarkably. Not any longer to expecting any state to be religious, but essentially to accepting a plurality of religions within any particular state. That was a major change. I mean, the practice had been up to that point, essentially, to accept it, but not doctrinally. So there are shifts occurring, and one of the things I'm going to be wanting to do in the third discussion is to precisely mention some of those as a potential way forward. So, in other words, I'm not assuming that the only changes that need to occur if you're going to lead to more reconciliation are changes on the state side. I'm absolutely sure that you're going to need changes on the religious side as well. So, wait for the third one on that. The third lecture. The second point you're making is I think, central to this discussion. Right? So the terminology is important here. And what you suggested, for those who may not have heard, was that a simple way forward is for the state to be neutral, to have for the public space to be a neutral space. The reason why that's particularly interesting is because it comes up right at the beginning with a conflict on the idea of resurgent religion that I mentioned at the beginning. Right? So as long as secularization theory puts religion into the private, then neutrality works. Yeah? So in other words, religion is in the private sphere, the public sphere is neutral, and everybody's happy. And of course, that's exactly the debate that's going on in France at the moment. Right? So a sort of more extreme version of neutrality is laïcité. The notion that the private is entirely appropriate for religion, but that once you, certainly as a French citizen, once you enter the public sphere, you leave aside all of those identities. You leave aside the notion of race, you leave aside the notion of religion, you leave aside everything apart from being a French citizen. And that's, you know, highly Napoleonic and highly Enlightenment based. And very, very attractive. Right? And the reason why you're putting it forward is because it is an attractive vision. As a way of resolving, however, some of these tensions, it's problematic in two respects. Right? One is, some of the religions, in particular, say, you've just misunderstood our understanding of religion. Right? Essentially what you're doing is buying into a post-Reformation Protestant view of religion. Right? That is, that the notion of religion is something that we have in relationship to the deity, right? And that's a personalized understanding. Yeah? So it works a treat, as we would say in English, right? It works really well for some religions, but not for others. Yeah? So there's in other words, one problem that arises is that if it's carried out in practice, it actually ends up discriminating between religions, right? Between those religions that are quite comfortable with the notion that it's a private sphere activity and those that aren't. So you may think you're being neutral, but actually the effect is that you're distinguishing radically between certain kinds of religious understandings and others. So in other words, you're being unintentionally biased in your understanding of what religion should be. The second problem is a more conceptual problem. The second problem is what you mean by neutrality. Neutrality is a very difficult thing to capture, really. And so I won't press you in terms of the different understandings that you might have of neutrality. But for example, the United States Supreme Court talks in neutrality terms. The French state talks in neutrality terms. They're very different countries. And the role of religion, you know the United States very well, the role of religion in these contexts, in the United States, is remarkably different. But it's still a Republican understanding of the role of religion. Right? It's still a neutrality-based notion of religion, and yet it would accept practices that would be absolutely forbidden in the French context. So in other words, there are different concepts themselves of neutrality. And I want to try to unpack some of those again in the third lecture. What I'm going to suggest essentially is that there's a difference between what some people have called secularization and secularity. But you're going to have to wait until the third lecture to get a full grip on that. But I'm very conscious that neutrality is a problematic term and that I have to think in different concepts, I think. Maybe it's coming closer to pluralism. And maybe we might be able to agree that pluralism is a better term. but that probably isn't going to make you happy if by pluralism you mean the exclusion of religion entirely from the public sphere.
Okay. Anybody else? No? Yeah, over there. Oh yeah, I want to. Okay, please just stand up because we don't have microphones actually.
Yeah.
Is there any room for giving dignity to an animal when discussing about human dignity?
Yeah. Good. Great.
Do you have anything sort of as an example?
Great. Well, if I hadn't anticipated that question coming up, I should have, right? So this is great. So there's two different issues coming up. There's a kind of procedural question that you sort of made a sort of joke about, but that I want to take a bit more seriously, which is how do you get into court? And of course, there's actually no problem about animals getting into court indirectly in several different ways. So you can have people representing them and so on. But so let's leave aside the procedural issue and concentrate on the important substantive question. So so there's a question here about the distinction between dignity and human dignity. And quite often we think of the two as being the same. But for the purposes of your question, it may be worth distinguishing them for the moment. I will come back to your question in a minute, but I want to make a distinction first of all. So one way of understanding dignity is that we should treat things the way they're supposed to be treated, according to what they are. Okay? So this applies to any object. So the way I should treat this pen is the way it's meant to be treated as a pen. Right? Or the way I use a fork is that I shouldn't, stab my children with it. Yeah? Or more likely, they shouldn't stab me with it. It should be treated, the fork should be treated according to what it is. So this is all getting back to kind of Aristotelian understandings of essential properties. Yeah? So one way of understanding the notion of dignity is that everything has its dignity, meaning everything should be treated according to the thing that it is. That's one understanding of dignity. So when you get to the notion of human dignity, and carry on this notion of dignity in the way I've just described, you get the notion about people, therefore humans, being treated according to the thing that they are. Right? Treated appropriately according to the thing that they are. Now that, of course, leaves open this huge question about what that means in practice. But let's leave that aside for a minute and just look at it conceptually. So from that understanding of dignity, animals clearly have dignity because we should treat them according to the thing that they are. Now, on an extreme level, that would mean, for example, that you shouldn't go treat animals because you're not treating them according to the thing that they are. You with me so far? So here then becomes a major problem. The major problem then becomes, is the distinction between, as it were, animal dignity and human dignity worth preserving? Notice the move that I've made is not to say animals don't have dignity, but rather they have dignity according to the thing that they are. So then we get to the question is, are animals different from humans according to the thing that they are? Yeah? Now that then gets us into this fascinating and very difficult question about whether we have an essentialist understanding, coming back to your essentialist point, an essentialist understanding of what it is to be human. That means that it's different from what it is to be an animal. Yeah? And what you're seeing is clearly on a philosophical level, significant questions being raised about that boundary line with several, I'm thinking of Peter Singer, for example, several philosophers questioning whether or not this distinction between what it means to be human and what it means to be an animal is worth preserving, or indeed based on anything that is concretely distinctive. And in particular, you get then to the biological advances in terms of our understandings that animals share a lot of DNA, for example. So you get biologicalist undermining of the distinction between what it means to be human and what it means to be an animal. So the question that you're posing seems to be a very simple question, right? And it's rhetorically, it's a great question because it opens up all these questions. But it's highly problematic in terms of A, what you think you mean by dignity, and secondly, on what basis you're going to make a distinction between what it means to be human and what it means to be an animal. Whether you're going to approach that on the level of biology, in which case there is a very considerable overlap. Whether you're going to approach it on the basis of the ability to think, the ability to express opinions, for example, the ability to have a notion of self-reflection. So we think of ourselves as human. Right? We have the ability to reflect on our species as a species. Do animals have that or not? Does that matter? You're also, of course, getting into the further question, since we're talking about the religious dimension of this, is that religious understandings of human dignity are quite often based on the notion of the image of God. Right? So the idea that arises in several of the major world religions, that we have dignity, human dignity, because we are made in the image of God, which is clearly an attempt, a way of distinguishing animals from humans. So, in other words, what your question does is to open up precisely the debate about what we mean by human dignity. That is the ontological question that I'm hoping to pose to you. Now, you want me to give you an answer about what I think, and that's sort of not particularly interesting at the moment, at least to me, because what I'm trying to do is to open up the debate in terms of how it's treated in the litigation context. That's what seems to be the interesting question, and where the conflicts about the understanding of dignity then have important implications for practice.
My question goes in the direction of the, let's say, philosophical dimension of what you have been talking about, especially regarding the normative dimension of human rights, before you to the beginning of your lecture. If we understand normativity in ethical terms, we refer understanding of basic principles that would allow us to justify this ethical normativity.
Great. So, so one response to that is to say, I'm not assuming that there is an answer to this. Yes? In other words, I'm prepared to think, to contemplate, that actually it is irreconcilable. That's an important admission. Right? So what I'm attempting to do is not to find a solution that is there, that I assume is there. I think it's a problem which needs to be examined as to whether there is a possible way forward. So that's one response. Second response is, I'm dealing with this, remember, primarily in the legal context. And the reason why that's important is because to assume the legal way of resolving this, if there is a resolution, is the same as a philosophical resolution of it, I think is a category mistake. In other words, we arrive at legal solutions that are not necessarily satisfactory in many other ways, that are not necessarily satisfactory in philosophical terms. There is, in other words, an overlap, and this is what I meant by the notion of judicial reasoning. There's an overlap between judicial reasoning and the categories that we've been talking about and all categories. But there isn't a complete coincidence between them. They borrow from each other, but they are independent systems of reasoning. And the system of reasoning that enables a satisfactory solution in a legal term may or may not be sufficient to satisfy the legal philosophers. So, to come to your point then, how can I arrive at a solution if there is one, in terms of what I'm interested in, if there isn't a complete satisfaction of drawing it from universal principles? I'm going to suggest, I think, that, here we're into the third lecture, I'm going to suggest that we don't necessarily have to satisfy the philosophical constraints and requirements in attempting to arrive at a nevertheless satisfactory view. Now, that would be entirely unsatisfactory if you think that the only solutions that are satisfactory are those that are also based on sufficient universals that will satisfy accounting purposes. But I just don't think that judges are or should be Kantians. Really, it would be nice if that's all possible. No, I'm not even going to concede that. I think it's a different operation. And so one of the trends that I've been quite uneasy about in some respects is the assumption and a lot of legal philosophy, in particular, following laws or following Kant in the last 34 years, that the way in which you critique legal opinions is to see whether they are satisfactory from a Kantian view. I just think that's underestimating the institutional constraints that judges and law should act on. So, again, if you come from that perspective, that the only solution is one that has to be resolved convincing, then you're going to be disappointed.
I'm a philosopher, so I like to ask you the philosophical question.
I'm quite right too. This is why this interchange is interesting, because I think we need to have precisely that kind of engagement, because what I'm doing is not philosophy, it's law. And that means it's different.
Well, the point is, I don't want to...
No, please do this.
No, I didn't... my starting point was not that there shouldn't necessarily be an overlap or a coincidence between the philosophical and the legal or institutional level. The question only came from the fact that this normative ethical dimension was
isn't a complete set. It doesn't. It's necessary but not sufficient. Yeah, for there to be an ethical dimension to this, because human rights is something that is that shares a space between, as it were, the philosophy of human rights and the law of human rights. So there's an overlapping element here. So in other words, the interpretation, legal interpretation of human rights, has to be in some way satisfactory enough with understanding where we're from an ethical point of view. But it doesn't have to completely satisfy the ethical position. So I don't want to be pushed into the idea that they're entirely separate.
No, but it's clear to me.
Okay. Thank you.
Other questions? No questions? I mean, I'd have more than 2 questions, but I'll leave those for tomorrow if there is enough time for me, because I prefer to leave the floor to the students or colleagues. So if there are no further questions, well, we'll set the appointment for tomorrow at 10:30 as well. Thank you very much for having been here, and have a good day.